Senator Ludlam.
Just rise to speak briefly one last time. I think this is probably the last opportunity to speak on this bill, which has been the subject of protracted debate not only here but in the other place all week. This bill is a pretty sorry story. Many things that started on a handshake between George W. Bush and John Howard ended in tears, and this is just another late straggling example of that. That's how this bill started. It's a bill, let's be really clear, about enhancing the trade in weapons and interoperability between weapons systems and defence research between Australia and the United States. The bill's been passed back to the chamber for concurrence. I'm someone who does not concur at all. I was persuaded by the arguments that Senator Johnson was raising in this very place only 48 hours ago. Over the last 4.5 years, I will put this on the record, although I may later come to regret it, I have come to develop a grudging respect for Senator Johnson. One thing that you could say about the Shadow Defence spokesperson is that he is across his brief. He knows his brief. You bring a defence bill into this place and Senator Johnson will give it the attention it deserves for the reasons that he brought to bear when he was advancing a perfectly reasonable coalition amendment. It wasn't the one that the Greens sought to move. Ours lapsed. It was not acceded to by the chamber. So we voted for the fallback position, I suppose, from my party's point of view, based on arguments run by Senator Johnson. And Senator Johnson, you must have turned out to be a pretty cheap date, because 24 hours later you have been rolled, Senator, through you, Madam Chair, by the Leader of the Opposition, who knows, with greatest respect to Mr Abbott, considerably less about these issues than you do. The consultation process on this bill, and that's therefore a bit hard to hear Senator Johnson come back in here waving your finger and condemning the government for blah blah, whatever we're condemning them for this afternoon, when you are participating and facilitating what you know and what everybody knows and what those in the other place lined up to slam this bill yesterday knows is a terrible bill. It's a badly drafted bill. It still has major outstanding concerns, notwithstanding the fact that we did, by negotiation with all parties, at least achieve some amendments on the way through. The Senate committee sent Defence and others back to the negotiating table to try and get it right, and the government was told to bring the bill back when it was no longer a work in progress. We are aware that the committee was forced to table its report 20 days early, and I understand that it's now fairly common knowledge, and Senator Feeney was good enough not to try and obfuscate this the other night when I put it to him. This is all about a press conference in Perth in November with Secretary of State Hillary Clinton, Secretary of Defence Mr Panetta. We know that that's what this is about, and that is why process has been so savagely abused in here. The committee was robbed of the opportunity to evaluate 10 pages of complex government amendments, and while I may be expressing a degree of dismay at Senator Johnson's actions tonight, I was genuinely surprised when the three coalition signatories to the dissenting report, to the committee's otherwise very good report into this bill being a work in progress, backflipped again. The magic 24 hours. Was there also a magic phone call from US Ambassador Jeffrey Blyke, who you would have to say has excelled as a lobbyist on this occasion in sticking up for the interests of the United States government? That's his job. Our job is to stick up for Australia and for Australian researchers and the Australian academic endeavour. The committee report did give some hope that amendments would be referred back to the committee because a dissenting report signed by the Greens and the Coalition could have ensured that that would happen. But no, that was not to be either. All the bluster, all the huffing and puffing, all the concerns and assurances provided to the universities eventually were found to be completely hollow. So it's not surprising, I guess, that Senator Johnson tips his hat to the chamber and then sits back down again. The bill was improved through Greens amendments, as I acknowledged, with Senator Feeney and Senator Johnson the other night, drawing heavily from recommendations and suggestions made by the universities. What I would take to be a more accurate reflection of the outcomes of the roundtable, we did improve the bill. A number of very serious offences that the researchers of this country are facing are postponed for 2 years. And in addition, the bill was improved through the establishment of the steering committee that will evaluate the workings of the legislation, will advise the minister and the research minister, and will basically pilot the export controls regime. The steering committee will also crucially and explicitly evaluate whether Australian researchers are penalised by this legislation more than the US counterparts. That's something. That's not nothing. That is a substantive improvement to the bill. Thank goodness the Coalition didn't sell us out on those in the House of Representatives as well. The bill was not improved as it should have been. We don't have to imagine this in the abstract because we had the language and we had the arguments put by Senator Johnson. The Senate passed an amendment that would have mirrored US exclusions for fundamental research, and it's as simple as that. The amendment implemented the Senate committee's view that legislation should not put Australian researchers at a disadvantage compared with their US counterparts. The NTEU stated that they were appalled at the failure of the House of Representatives to legislate amendments to the Defence Trade Controls Bill proposed by their Senate colleagues only 24 hours earlier to preserve the freedom of intellectual inquiry for Australian university researchers. The NTU stated quite correctly, university researchers now face a great deal of uncertainty about what research they can legitimately exchange or publish without potentially facing criminal sanction. An even worse outcome is that the government and coalition have relied upon a barely comprehensible reference to national interest considerations at the expense of Australia's research and innovation efforts. This is worth quoting at length, isn't it? They go on. The Minister for Defence, Mr Smith, appears to have a limited understanding of the nature of academic research when he said that the legislation does not impact on domestic research. The union's objections to the legislation are that researchers might be committing a criminal offence with a maximum of 10 years imprisonment if they share their thoughts or results for what is ostensibly domestically focused research with overseas peers and colleagues for review or verification. So, a very important question that has not been answered about this amendment and about Australian researchers being accorded the same exclusions from export controls as their colleagues still remains. In explaining why I did not support the insertion of this amendment into the bill, the minister in the other place, who I should say is the only person in the course of this entire debate who stood up and unequivocally defended the bill. And good on him, that's his job, that's fine. Everybody else who's spoken to this bill has slammed it, or perhaps damned it with faint praise, as I might perhaps summarise Senator Feeney's contribution. The minister said, "I have come to the conclusion that to do that would undermine fundamentally the basic structure of the bill and would not meet the standards required to ratify the treaty." Similar to language to that which Senator Feeney just read in response to Senator Johnson's contribution. Now, the congressional record of the United States Senate of 29 September 2010 at pages S1722 and 1723, maybe Senator Feeney, you even have a copy of the record before you, states only as a condition of ratification the following: that Australia has enacted legislation to strengthen generally its control over defence and dual-use goods, including controls over intangible transfers of controlled technology and brokering of controlled goods, technology and services. Now, I'm taking to mean the operative phrase in that statement from the US congressional record, enacted legislation to strengthen generally its control over those things that I've listed. I'm happy to table this, Senator Feeney, if that would be helpful, because I'm going to put this question to you in a moment. As the Defence Trade Control Bill meets these requirements in spades, irrespective of whether Senator Johnson's perfectly drafted Section 9A is included in the bill or not, can anybody explain to me, either the government or the opposition, you're both voting to disregard the amendment that was passed the other night, advise of the detail of any standard or similar requirement for the control of intangible supplies of technology on the DSGL that the government of the US has imposed on or communicated to or requested of Australia in connection with future US ratification of the treaty? That is the question on which this all hinges, isn't it? So I would like to hear anything at all that the minister's got that's been put in writing that defines what the US means when it says that we need to enact legislation to strengthen generally its control over defence and dual-use goods. And if there hasn't been an insistence upon any such threshold standards for strengthening generally, which I think is the phrase upon which this debate hinges, who has imposed them? They've been imposed domestically? Where did they come from? Senator Feeney, can you please provide us with an answer to that key question?
Minister.
Thank you, Chair. Senator Ludlam, as it was on Monday, it remains today the fundamental assertion of the government that the Amendment 9A, the insertion of Clause 9A into this bill, as was proposed and as was executed on Monday, has the effect of weakening the legislation rather than strengthening it. And let me be plain. Earlier today in this chamber, you spoke earnestly, passionately, thoughtfully, as you usually do, about the uranium debate. And I think it's worth noting that this is uranium that would be exported under International Atomic Energy Agency safeguards and a bilateral Australian safeguards agreement. Yet by insisting on this amendment to this important counter-proliferation legislation that would enshrine in that legislation you are proposing free rein for any person who has an intent to publish sensitive technology, to export this sensitive technology in electronic form to anyone in any country, and to do so in the absence of any safeguards. Indeed, this would apply to technology that is crucial to the development of nuclear weapons. And so, Senator Ludlam, what you are effectively doing is proposing the unrestricted and unregulated transfer of nuclear-related technology to anyone, anywhere in the world. And you are proposing to extend that to technology crucial to the production of chemical and biological weapons. So we say that by insisting on this amendment, you are in fact weakening the anti-proliferation position of this government, and of course, as we have said all along, the amendment has the effect of fatally undermining the legislation. Now, in terms of the amendment and its particulars, I can perhaps go through the amendment clause by clause. I'll try and do this swiftly. Clause 9A describes the Act as not applying to information in the public domain. Information in the public domain is already exempt from controls under the Defence and Strategic Goods List. 9AB exempts any information that has been or is intended to be published in any publication to members of the public. So, in effect, this clause would mean that any person could decontrol sensitive material simply by the act of intending to publish it. As I have mentioned previously, once the material has been published and is in the public domain, it is not controlled under the DSGL. That would not only decontrol the sensitive information in Australia, it would also decontrol it across other countries that have an exemption for information in the public domain. It would weaken the current control arrangements by allowing tangible transfers of sensitive technology, which are already controlled. These implications are completely unacceptable to the government, have the potential to threaten Australia's national security, and I cannot help but suspect would not, if comprehended, be supported by your good self. It is at odds with your stated objective, which is to strengthen the counter-proliferation regime in this country and internationally.
Senator Ludlam.
I suspect the minister has chosen his words carefully enough to force me to stand up again to refute that, because you know, Minister, that not only do I wish to restrict the transmission of technology and the techniques behind nuclear weapons proliferation, I'm an advocate of the abolition of this technology altogether. And again, Senator Feeney, you have conducted this debate mostly in terms pretty measured, apart from the last statement, which says that the amendment completely blows a giant hole through the entire bill and would allow people to start sharing enrichment technology with Iran. Now, you know for a fact that we would not. That's correct. I'm verballing you there somewhat, Senator Feeney, but I completely understand the subtext of your comments. You know, in good faith, that we would not craft or vote for an amendment that allowed that. You could certainly be reasonably confident that Senator Johnson would not put his name to an amendment that allowed that to occur. And so I just regret to observe that right at the late stages of the debate you've just drifted into unhinged hyperbole, and that's a great shame. I'd like to pay tribute to some of the people who've worked hard to educate and try and talk some sense to the MPs who are grappling with these complex and quite technical issues. Some pretended to hear them, but actually we did hear what Professor Jill Truella, the Deputy Vice-Chancellor of Sydney University, has been telling us as, for example, there are many voices in this debate but the Deputy VC has been a leading advocate for just a cooling-off period and a period of time firstly for the committee to work through these amendments, but ultimately for the chamber itself to see reason. Universities Australia have also played an important role in the debate, and as have the NTEU, whose recent statement overnight I just quoted from extensively. But I would like particularly to thank Jill, who has worked, and some of her staff and the people around her, who have worked tirelessly until pretty late at night for quite a period of time to try and get the MPs to see reason. The image in the House of Representatives last night said it all. The major parties are better at obedience than they are at lawmaking in the interests of our universities, our innovation and our research, and they knew it. And that was the saddest thing. As Senator Bishop did the other night when he stood up and slammed the bill, my staff were quite critical of me when I returned from the debate, that why can't you be as impassioned as Senator Bishop was in condemning the actions of his own government. The Independents and the Greens tried our best, and I would also like to acknowledge those members of the other members of the crossbench in the other place. We will continue to monitor these issues, and I'm at least pleased that we made the substantive improvements to the bill that we did to buy some breathing space and perhaps over a period of 24 months create some space for second thoughts, because I suspect this bill is going to need it.
The question is, no, Minister.
The
question is that the committee does not insist on its amendment to which the House of Representatives has disagreed. Those of that opinion say aye. Against, no. I think the ayes have it. Division required. Ring the bells.